Okay, thanks for coming. We can get started. I wanted to thank everybody for coming, and I wanted to also mention that this is being recorded, and it will be on a webcast afterwards. And also, for those who are interested, this is all for a CLE credit. So if you wanted to sign in at the front desk, you can make sure you get, if you're an attorney barred in New York or where CLE is required, like in California, we offer 1 hour. Thank you for coming. I'm Alex Koff. I'm a partner here at Venable, and I'm very pleased to have Osborne Clarke with us and our 3 guests. I focus on international and cross-border issues, and I serve as general counsel to U.S. companies and foreign subsidiaries in the United States. I'm in the primarily in the Washington, D.C. and Baltimore offices. I'm joined here by my colleagues Katie Vickery. Katie is a partner specializing in regulatory and compliance from the London office of Osborne Clarke, and to her left is Alexandra Glatz. He's a specialist lawyer focusing on competition and distribution law, is based in OC's Paris office. And last but not least, on the far end is Dr. Andrea Schmoll. She's from OC's Germany office, and she focuses on intellectual property law. So with no further ado, I'm going to turn it over to Katie, and she will be discussing first, and then what we thought we would do, and subject to all of your thoughts as well, is we would take maybe 5 minutes or so for each of our OC guests to talk about their respective areas and selling into Europe. And then we can, the second part, we can talk about specific questions, maybe a comparison between how it works in the United States and how it works in Europe. And then the third, probably what's really focusing on a lot of people's minds, is the Brexit issue. So with that, Katie.
Brilliant. Thank you, Alex. And good morning, everybody. It's very nice to be here. We're still slightly jet lagged. We flew in yesterday, so you might have to bear with us. But we've hit the coffee, well, some of us have at least. So we'll do our best. Sure. Am I on?
There's no red light. So.
Yep, you can hear me. Fab. So we're going to cover our various areas. And as Alex says, I'm a regulatory and compliance lawyer. I specialize in the retail and consumer sector. So I thought it might just be helpful to give you a bit of a sense of some of the trends that we're currently seeing in Europe in relation to retail. And I suspect quite a lot of these will be very similar to what you're seeing in the United States, but it'd be quite interesting when we do the panel session to get your views and sort of see whether the comparisons are true. So one of the first points, I mean, very obviously, is about the increase in online sales. But what perhaps surprises some of my American clients that come to me is just how important this is in various parts of Europe. Online sales from a retail perspective in UK and Germany now exceed the amount of online sales in the US. So we are a nation of shoppers who like to go online. Currently represents about 20% of all sales are made online. And we've seen it that businesses are set up over in Europe, not appreciated the importance of delivering that, and actually haven't put together a very comprehensive online offering, and have failed as a result. Most notably, the Australian business Bunnings that came over, or Wesfarmers that came over and set up with a big company called Homebase and Bunnings, and just crashed out because they just really didn't think about their online offering. So that's the first point. We're also seeing, and this is, I'm sure, linked, an increase in store closures. So there's a real sort of shift and a repositioning in the retail market as to how people are using their stores. A lot of those kind of out-of-town, large shopping precincts are really struggling, and you're seeing much more in the way of smaller shops, much more in the way of convenient shops where people can go and particularly do things like click and collect. So you order online and you can collect from your local store within 30 minutes, now becoming more and more common and more popular. But also using stores more effectively to try and meet that online demand. So using stores as places where you're actually going to hold stock and you're then going to be able to get it out to customers really quickly. Digital transformation, that shopping experience, very much big trend in retail. So people don't go shop. People are shopping now to have an experience of going shopping. You know, it's the experience of being there in the store. What else is the store going to offer me while I'm there? What am I going to see and feel when I'm shopping. And that's a really big part now and that kind of distinguishes the successful retailers from those who are not doing it. But you see the digital push with things like smart mirrors and augmented reality being used, much clever emphasis on the way that goods are marketed and advertised and how they're targeted at individual consumers as they walk around the store. And that's an ever-increasing trend. Emphasis on natural and transparent, huge drive here. I mean, I advise a lot in the product space. A number of instructions I'm getting in from businesses who really want to shift away from any concept of them having anything artificial in their product. They really want to present a very clean product, a very natural product to the consumer. And that links in with that point about packaging and sustainability. Packaging has become a real issue in Europe. That's something that a lot of consumers are trying to move away from, having excess packaging, particularly plastic packaging. And you're seeing a number of retailers coming up with some schemes about how they can reduce that amount of packaging that they're using, or finding better ways of recycling it. So packaging, and particularly plastic packaging, is a real no-no there. So those are some of the trends that we're seeing. I'm hoping that some of those resonate quite a lot here in the States as well. I suspect they do. There's some nods going around the room. So what does it mean if that's retail in Europe and you are sitting here as an American business and you're thinking, right, well, I'm going to sell into Europe. What are the sorts of things that you need to think about? And we look at it from the perspective of bricks and clicks. I don't know if that's an expression that you're familiar with. Bricks, obviously, physical stores. Clicks, your online sales. And I just wanted to touch on just some of the things that we talk to businesses about. And typically, when somebody comes and says, I'm interested in setting up in the UK, we will produce a launch plan for them, which runs through some of these issues that they've got to cover. Property, obviously, is where you're going to start if you're going to set up a store. But there is so much difference between all those various European nations as to how you're going to go about securing that property, and how you need to go about getting the permissions that you need if you want to do a store refit, if you want to alter the property in any way in order to get it to fit within your retail brand. Data privacy, GDPR, General Data Protection Regulation, has been a huge thing across Europe. It's so heavily regulated now in terms of how data is controlled, how you obtain data from consumers, and how long you hold it for, and who you share it with. But also thinking, well, if you're a US-based business, actually, are you going to be having any data that's going to be shared between the US and Europe? Because again, that's a big issue that you need to get some proper advice on and have the proper agreement set up in place. We're also a very regulated continent. We have a requirement to have a lot of policies and documents around things like health and safety, bribery, competition. Just to run a business, you need to have a lot of documents and policies and procedures in place. My sense is much more than perhaps you do in the States. That's something that, again, people find surprising. So getting those in place. Waste disposal I throw in because I have an American client who got caught out on this recently. People don't realize that, you clearly as a commercial unit, you produce a lot of waste that comes out of your business. And because it's commercial waste, you've got to get the appropriate consents to deal with it. You can't just stick it out on the street. Unfortunately, there have been a number of American businesses who have received penalty notices as a result. So waste, don't underestimate that. Insurance, mandatory to have employers' liability insurance. Traffic approval, you've got to get your stock to the store. So you need to have special permission in certain areas to actually be able to unload and to actually put all your stock in store. So those are some of the common issues that you might need to think about. Online, clearly website requirements. Now, often it's much easier to get some advice at the outset of building your website rather than trying to retrofit your existing US website to fit European requirements. The consumer law provisions that we have, the distance selling provisions that we have, mean there are lots of ways that you need to set up your website, buttons that consumers need to click, information that consumers need to be given before that contract to sale is concluded, that you really need to make sure your website is set up properly to do that. So getting some advice early doors is much easier rather than trying to then make the legal bits fit in. Warranties, all European consumers have, at a minimum, a 2-year warranty for defective goods. Some member states will have stricter provisions on that, so it can be in excess, but you can't reduce that, you can't contract that away. Everybody is entitled to that. So that means that for those 2 years, a European consumer is entitled to receive either a repair or a replacement good, and if you can't offer that, then you have to offer either a full or partial refund for that good. Similarly, if you sell the product there, you're allowed 14 days within which you can just simply return the good, and that's a sort of cooling off period for distance selling. Language and product information, probably the question I get asked the most. If you are selling to any of the currently 28, soon to be 27 European member states, you have to sell in the language, the recognized language of that member state. So yes, that does mean that you have to translate certainly parts of your website into all of the languages that are covered across the European Union. For products, there's very specific information that must be translated, so anything that relates to safety, to conditions of use, anything that the consumer needs to know about how to actually get started with the product has to be translated into that local language. Some countries go further, so Alexander will tell you in France that absolutely everything has to be translated into French. All of the marketing fluff, shall we call it, needs to be translated into French, and they're pretty strict actually on enforcing in that. So just thinking through the practicalities of how you're going to get the language information there is important. And finally, geo-blocking is a regulation that has taken effect at the end of last year. So this basically prevents you discriminating against people based in other member states when you sell your goods. So you can't refuse to sell, if you're selling in France, you can't then refuse to sell your goods into Germany just because your consumer is located in Germany. Now, importantly, that doesn't mean that you therefore have to ship. So if a German consumer came onto the website, ordered it, from a French-based business, French-based website, it doesn't mean that the French-based website has to then ship it to Germany or send it to Germany, but you do have to make it available for that German consumer to come and obtain it from the border or from somewhere in France. But you can no longer discriminate, and you can't do things like altering your prices. You can't charge the Danes more than you're going to charge the Polish, for example. All of that has now gone. So it's a real rattle through the list there of regulatory requirements, turning very specifically to products. We operate on the concept of placing on the market, which means if you are based in the EU and you're holding stock that is available for sale, you are viewed as placing on the market. And that means that you are the entity that takes responsibility to ensure the product conforms to all EU law. Now, if you are a US business and you don't have a European entity, then the importer takes on that responsibility. So the importer would take on the responsibility for making sure the product complies with EU law. But you must have an EU address. So whether it's the manufacturer's address, if they're based in the EU, or the importer's address, you must have an EU address on the product labeling. Labeling and language requirements I've talked about, it applies just as much on the packaging. So, you've got a lot of translation to fit in, sometimes onto a very small label, and thinking about how you do that and how you're going to translate various bits of it is challenging. CE marking, so this is our conformance mark. So it's quite similar in the States. You have the FCC mark, which you'll probably be more familiar with. So for certain goods, it's not just electronic goods. It applies to toys and big bits of equipment like lifts and escalators, all sorts of things. You have to make sure that they're tested to a certain standard. And once they've achieved that standard, you put those letters, the CE mark, on the bottom of it to show that it conforms to those standards. Marketing claims. We are much stricter than you guys are in the US. You cannot make the claims or try and sell your products with the kind of the big slogans that a lot of people get away with in the States. Just doesn't wash in the UK, well, certainly in the UK, but across Europe as well. The UK is particularly stringent on it. And finally, packaging and disposal requirements. We have rules about when you import product into the European Union, if the packaging that surrounds your goods, so not just, so if you bring in shoes, it's not just the shoe boxes, it would also be the pallet and the shrink wrap and everything else. If that exceeds a certain threshold, then you have to register with a regulatory authority and you have to commit to recycle a particular amount of that packaging. It catches out so many US businesses who have failed to register. And again, they are really strict on the enforcement of that. So you have to make sure you are within the right threshold amounts. And similarly, disposing of it, if you have electronic goods, for example, then you have to make sure that they're disposed of correctly because it's viewed as waste electronic equipment, and general recycling obligations that apply as well. So I put some of the sort of little symbols on the bottom of the slides there. CE marking, which hopefully I've just talked about and you guys can see. Anybody know the green circles and the arrows? Anyone know what that is? Not recycle. It's connected to recycling. This is like a little pop quiz here. So this is called the green dot. Again, you see it applies across Europe. It relates to being part of a recycling scheme, but it's a licensed mark. So if you put the green dot on your product and you've only got the license maybe in half of the member states, but you're selling in all member states, then you commit a breach of the license requirements in those member states. The wheelie bin with do you call it wheelie bin in the States? The kind of bin with the little wheel. So you know what I'm talking about. Wheelie bin with the cross through. So that's the waste, that's the WE symbol, the waste electronic symbol that has to go on. Next one across. Anyone know? If you're keen on your moisturizer, you might know about this. So this is the cosmetics one. So this is a little symbol that goes on the back of your cosmetics bottle to tell you once you've opened it, you have to use it within 12 months, or whatever month period is in there. And the one at the end? Danger of some sort. Good. Yep. This falls within something called the CLP regulations. There's a whole set of these little diamond hazard marks. If you sell household goods, so more like detergents and that sort of thing, there's a whole host of these little diamond symbols that you need to put on to show that there's certain hazards. This one means harmful or acutely toxic, but there's a whole raft of symbols as well. So it's just a little fun around symbols. I'm going to hand over to Alexandra to talk to you about the very serious topic of competition law. And
just for everybody who's listening in on the tape, just to give you a sense of where we are, we're going to have Alexandra talking now for about maybe 5-10 minutes, and then we'll have Andrea talk for another 5-10 minutes, then we'll open up for some questions, and then we'll focus in on Brexit, just to give you a sense of where we are.
Thank you. So competition and distribution. Well, the legal trends that you would face in Europe are probably similar to those that you face in the regulatory space that Katie just mentioned. So maybe what you would want to know is that we have two parallel regimes, EU law and national law. So as our continent is quite regulated, indeed all this is written in laws and regulations that you will have to assess and to be aware of before starting your own business in Europe. Now, that's the downside of it. The interest of all that is that you would know what you have to do once you would want to enter the market in Europe. So in a way, it's also a way to be more sure of your issues and to be prepared while you are doing business in Europe. So as far as competition issues are concerned, you have two basic principles. Anti-competitive agreements are prohibited, both according to national law and European law. European law would be applicable when you would have cross-border effects within the EU. And you have also EU block exemption, which is available, including for selective distribution. This is a topic that we'll discuss about in a few minutes. I don't know, I think in the States, Alex will maybe confirm that you don't have the concept of selective distribution, although you do have, of course, issues around that. But I think your system is a little bit different. What is selective distribution? Is a method of distributing products or services where the supplier wishes to limit the number of its resellers based on qualitative or quantitative criteria. So you will set up a distribution network based on those criteria, which have to be objective and known from your resellers from the beginning. And once you do that, only those resellers that would be authorized to distribute your products would be able to distribute them.
Yeah, in the United States, it's a little bit different because of the competitive issues viewed from the perspective of how it will affect the U.S. consumer from a competition standpoint. But you are starting to see a little bit in the online channel cleanup issues for online sales, where people are trying to enforce rules and saying this person is an authorized distributor in that context. And because they're an authorized distributor, the rules say that the product can be offered as new. But if it's not an authorized distributor, it can't be offered as a new product, but instead it's a used product which may have less cachet and less of a price point, which then raises that box price to increase the sales that are being offered online. So a little bit moving, but it's not the same.
Yeah, in a way, we're all getting to be aligned on the same principles, I think. Yeah, and then the other thing you have to know is the abuse of dominant position, which is also prohibited, which is applicable to those companies that would have a dominant position, and while having this dominant position, they will abuse of that position on the market by restricting competition. Now, maybe the last point to know on the trends is that until recently, all the case law that we had and the regulations that we had in Europe were favoring online sales. And I think Andrea will also discuss a little bit from an IP perspective around that. Now the trend is a little bit more balanced, I would say, and probably the next regulations and the issues that we'll have in Europe will try to balance a little bit more this around protecting brands. So this is something you have to be aware of. So we were talking about block exemption. So agreements under the vertical block exemption regulation would be block exempted, would be in a safe harbor, and will not be prohibited under both European and national competition rules. But of course, you have to abide to the applicable rules for those exemptions. And as far as selective distribution is concerned, that would be that you have to have both from the reseller and the supplier less than 30% market share, no price restrictions, no restrictions on sales to end consumers. And once you abide to those principles, you will have your distribution agreements and then your network compliant with the applicable rules. So you have to have this in mind in order to have a compliant distribution network. What you can do while you're having a selective distribution network in place, you can, of course, establish objective criteria for selecting your resellers. You can refuse to supply to those who do not meet the criteria, which is, of course, interesting for also online sales, because this would be applicable both to brick and mortar stores and to online stores. You can prohibit resellers from selling to unauthorized resellers. So this would mean that the whole network will be selling the products across the network, but not outside the network. You can prohibit wholesalers from selling directly to consumers. And of course, as I said, when selling online, you will have to have your resellers abiding to the criteria you have established. What you cannot do is, of course, to restrict resellers from selling online, meaning that once you have a brick and mortar store wanting to sell online, you have to allow them to do that based on the criteria you have established. You cannot impose restrictions on retailers to dissuade them from selling online, restrict authorized retailers from selling to other authorized resellers, restrict authorized retailers from selling to consumers, and impose fixed or minimum resale prices, which is probably a similar topic that you have in the States, although I know you might be a little bit more, less stringent than we are in Europe on those issues. But in Europe, this is something it's totally prohibited. So fixing minimum prices, it's totally forbidden. Then the IP stuff.
Thanks, Alex. So I hope you're still awake, although it's almost early in the morning, at least for us. It's a bit, yeah. So very happy to be here. And as Alexandra and Katie, I'm also a member of the retail and consumer team of Osborne Clarke, which means that, we are focusing on retail clients, in particular global retail clients coming into Europe and requiring our help with respect to all areas of law. So that's why it's good to have a group of people, focusing on this particular sector, knowing what's going on in the respective sector and kind of working hand in hand, which really helps a lot. So I'm the IP person in the team, and I must admit it's a kind of challenge to guide you through the hot IP topics within 5 minutes, but I will try my very best to do so. So what we are currently discussing are the topics I have displayed on the slide. First of all, influencer marketing in Germany or in Europe. So influencer marketing, as you all know, it's a very, very strong tool in order to convince consumers to buy a specific product. And although it was always very clear that influencers and influencer marketing would fall under the regular marketing laws, it appeared that the competitors and also the competition watchdogs kind of turned a blind eye on what was going on with influencers, because most of the influencers did not mark their posts as advertisement. So for a couple of years, it was very, very quiet, and then I would say 2 years ago, the competition watchdogs started to sue influencers, but also companies entering into paid cooperations with influencers. And what now is required is that you really, so whenever you are using an influencer, that you ask him and that you request him to post and to mark any of his posts at advertisements. And that you're not only using the hashtag ad or hashtag sponsored by, but for example, for Germany, you need to use the proper German word Anzeige or Werbung. If not, you can be subject to fines, but also to civil proceedings and injunction proceedings. And to be honest, in Germany, injunctions are a very powerful weapon, because an injunction means that you have to stop immediately. And also, if you are using an ad which is intended to have effect in Germany, for example, you are subject to German law, and you can be brought to German courts. So that is something you should bear in mind, that the entire influencer marketing has a very international angle as well. And whenever you intend to enter into an agreement with an influencer, make sure that you really kind of shift the risk, sorry to say that, to the influencer, and provide for proper also indemnification provisions. So the next hot topic, and actually it's my favorite topic, trade secrets. For you US Americans, trade secrets are long time regulated, I think, and you kind of have a proper definition of trade secrets. We Europeans, we were a bit behind, whatever. So we had a very fragmented system and a very diverging protection levels. For example, in Finland, nobody knows what is a trade secret, whereas in Spain, you had a very matured protection system already. That's why the European Commission decided some years ago to harmonize the entire trade secrets protection. Because, of course, if you do not have a harmonized system, companies are reluctant, to share their trade secret with other companies. So the Trade Secrets Directive entered into force in 2016 already, and the implementation period to implement the Trade Secrets Directive, the minimum requirements of the Trade Secrets Directive to national laws within Europe, already expired in June last year. And most of the member states have enacted proper Trade Secrets Acts, not so the Germans. We are behind again, but we will. There is a draft out there, and I'm sure that we will have a proper trade secrets legislation soon. What I would like to bring to your attention is that trade secrets in Europe now, or trade secrets protection in Europe now, requires the companies to take active measures to protect their trade secrets. So trade secrets law, on the one hand, gives a lot of sanction mechanisms and a lot of protection for trade secrets, but on the other hand, you must show that you really, that you took measures to protect your trade secrets. And to be honest, most of the, in particular, mid-sized companies not even know what trade secrets they have. So for them, it's just like, oh yeah, trade secrets. Oh yeah, I think we have some, but we don't know who is the one who owns or who has the trade secret in his mind. We don't know who has access to the trade secrets, and this can be a huge problem. In particular, if one of the key employees is leaving the company. Most companies feel safe because they have post-contractual confidentiality clauses in the employment agreements. But to be honest, these clauses are not valid. We call them catch-all clauses, and they're not valid at all. So if one of the key employees, for example, in the R&D space, is leaving the company, he can take the entire trade secrets, all trade secrets with him, unless you have identified and you know what trade secrets your company have, and enter into a kind of additional agreement specifying the respective trade secrets and obliging him not to, disclose it to anyone else. And also, trade secrets have become a compliance topic in Europe, because the liability has also is much stricter now. The liability for infringing upon third-party trade secrets. For example, if you have a new employee on board, and this new employee surprises you on the very next day with a super great innovation, and you don't ask him whether this innovation might be the one from his former employer, then one could argue that you acted negligent in this respect, and you would be on the hook. So this is a huge topic in Germany, and you might, and not only in Germany, but in Europe, and you might see that if you have European contract partners, that this topic, will be brought to your attention, that they want to enter into new NDAs, or that they really, would like to focus on proper confidentiality clauses in the agreements.
Yeah, I just wanted to add one thing very quickly. I didn't mean to interrupt, but on trade secrets and injunctions, two things you've mentioned, selling into the United States, there's a procedure, it's called Section 337. It's 19 U.S.C. 1337 of the U.S. trade law, and it gives a huge, powerful weapon. And about 5 years ago, the case at the U.S. International Trade Commission where these cases are litigated was called the Tianru case. And in that case, there was an allegation that there was a theft of trade secrets that occurred wholly outside the United States in China, and had to do with steel railway wheels. So there was a company, Tianru, which negotiated with the U.S. entity. They decided not to execute the license and the agreement for these particular, the IP way to make these steel railway wheels. There was another company that actually got that license. So Tianru, the allegation was in the case, hired the employees from that other company, brought them over, and those employees took trade secrets with them. And the U.S. court, through the 337, which is the intersection of international litigation and IP, and the remedy isn't money damages, the remedy is excluding the products from the U.S. market. And that's a strong injunction. Yeah. They applied the ability to say, you stole these trade secrets abroad, the conduct occurred wholly in a foreign country, and we're still going to permit this statute to apply. And I haven't seen these cases emerge yet with the overall war between the United States and China on the trade war issues under Section 301. But that could be another area to watch. So if you're selling in the United States and your products are being stolen abroad, even as a foreign entity with a non-U.S., as long as you have a sale in the United States, that's another hook in the U.S. jurisdiction.
Oh, that's really interesting. And in Europe, all most companies have been overwhelmed by GDPR, and they were all discussing GDPR and thereby neglecting trade secrets, and that there was this huge development. And in my view, I mean, trade secrets means the crown jewels of the companies, right? Yes, GDPR means that there may be a potential fine, a huge fine, and I agree that GDPR is important. But still, I mean, trade secrets, you know, it's a very essential of the company. So companies should be aware. At Osborne Clarke, we are a bit techie people, so we are developing a database for trade secrets. So to help our clients, you know, to identify the trade secrets, to also document who has access to what kind of trade secrets and all that. And I think that this is really helpful. Do I still have time?
Yeah.
Okay. So talking about another development, another huge development, and what everybody in Europe is talking about, of course, is artificial intelligence. And you know, we Germans are a bit special, in particular when it comes to shopping. I agree that we like shopping online, but also we kind of return to shopping in brick and mortar stores, but we do expect a lot. So we want shopping to be an experience. And that's why artificial intelligence kind of enters the brick and mortar stores and becomes more and more important, and also helps many of our clients to survive. So, of course, there are a variety of IP issues relating to artificial intelligence, and I don't have answers to all of them. But one of the most important questions is who owns the IP if it is generated by using artificial intelligence? It's a bit this monkey selfie discussion, you may remember. So this is a question which is which you cannot solve by law or by applying the statutes, because, you know, obviously the statutes were not aware of, you know, artificial intelligence. So it's very important then that when you enter into an agreement with someone supplying you with products using artificial intelligence, or into cooperation agreements dealing with artificial intelligence, that you include provisions regarding the ownership of the respective IP. I mean, if you agree with your partner who shall be the owner, who shall be entitled to file patents, that makes things a lot easier. The same is true with respect to liability. I mean, who shall be liable if damage is caused because the artificial intelligence system, you know, is making a mistake or is, you know, infringing upon third-party IP rights? Make sure that you include proper language in your agreements, because the statutes will not be able to help you. So just a very, very quick glance at some high-profile cases which were decided in 2018. And I will not discuss all of them, although I would like to, but Alex is, you know, getting a bit nervous. No, but I want to focus your attention on one case which really is important. It's the Kanebo versus Metro case. And it goes a bit in the direction what Alex told you before, the selective distribution systems which are allowed in Germany and which are very important for, in particular, luxury brands to uphold the luxury aura, if you want so. And in December 2017, there was a very, very important decision by the European Court of Justice called the Coty decision. You might have heard about that because it really, you know, it was spread around the world, in which the European Court of Justice allowed Coty to prevent its distributors within a selective distribution system to sell via platforms such as Amazon and eBay. Because there was a lot of case law before which said that you are not allowed to prevent your distributors from selling via using eBay and Amazon. So this was a kind of revolution already. And then since Coty only applied to the online sale, the case Kanebo, which is a Japanese luxury cosmetic manufacturer, versus Metro, was long awaited. Metro and Real are like the European Target or Walmart, if you want so. And the Kanebo, very, very expensive Kanebo products were sold at Real. You know, that's really like, you know, not high quality and not very, you know, very sexy. And the question that arose was whether the licensor, the Kanebo in this case, whether the licensor was able to prevent Metro and Real from selling these products based on trademark law. And And the Higher District Court of Düsseldorf, which decided this case, said, yes, in case where the luxury aura is damaged, this should lead to a situation where the trademark rights are not exhausted. The doctrine of exhaustion means that when you are, selling products with the consent of the brand owner, you cannot later say when the products are resold, look, my trademark rights are infringed. And so this very decision, in my view, is a revolution and helped many of our clients because, we often face the situation where the luxury products are sold in Rudi's Restaurant or in very, how do you call it in English? Like stores where you can buy stuff for $1, for example. And until this very decision, we had no instrument to fight against that. So in my view, that was the most important decision last year. Okay. Okay.
Thank you. All right. So we committed to an hour for those on the tape as well as those in the room. We are currently, we want to reserve 15 minutes for Brexit. So that gives us maybe 5 minutes or maybe even 10 minutes for a discussion for questions from the floor. I've got some questions, but I want to see if anybody here has something they'd like to raise, or I can exercise prerogative as moderator to ask. So do I see any hands? I'll ask the first question. Oh.
One quick one I have. In terms of the luxury branding, who decides what qualifies as luxury?
So let me just repeat the question. So the question is, in terms of luxury brands, who decides what qualifies as a luxury?
Very good question. Very good question, actually. I would say the judges, depending on the good or smart arguments of the lawyers which were brought forward. But in fact, it's the most debated question after the Coty decision. Alexandra, correct me if I'm wrong, but because of course everybody wants that, wants to take advantage of the Coty decision and also the Kanebo versus Metro decision. So, it's very, very difficult to answer.
Of course, I agree with that. On one thing also, you can also a little bit prepare this through your contracts, because within the contracts you can explain why you are, let's say, distributing your products through a selective distribution network, which would mean that your products require that kind of distribution, meaning that you have this luxury aura to protect and so on. So it won't be 100% bulletproof warranty, but it's still something you can do through your contracts.
I had a case where one of my fashion clients wanted to stop a Target like supermarket to sell their clothes. The problem was that my client also sold cosmetics under this very brand at the supermarket. So we could not really argue that the brand was luxury. No.
So let me ask one question. I think thank you to our panelists for talking extensively about online and bricks and clicks and products and selling into Europe with a hard good, a manufactured good. But maybe an unfair question in a very short, compacted period of time. But I was curious about if somebody's looking to sell into Europe or expand into Europe, and they're looking at selling a service or a software or a consultancy, what are the rules for expanding into Europe, and how would you go through the day-to-day responsibilities? And here I'm thinking, for instance, on that fine line in the United States between an independent contractor and an employee, and the attempt to avoid commercial presence in Europe with all of the tax implications and the employee rights which would attach, which would limit an automatic right for termination, which some people enjoy here in the United States, and withholding for employees and benefits and pensions and things. Where is that line in Europe, to the extent that you can compress that to a very short period, and if it's required that you need more time than that, we can move on to the next step too. So.
Okay, that was a lot in that question, Alex.
I mean, in terms of the online sales point, it applies as much to services. If you're selling to consumers, all of the rules apply to services as well as to products. So it's the same principles that are there, and the same protections also that operate. It's obviously different if it's a business-to-business model, but here in this context, we're talking about business-to-consumer. So that applies. I'm not sure on the employment, the second part of the question, because that was a different.
So in the United States, there's rules that, and there have been some relatively recent, like in the last 5-10 years, rules regarding the fine line and the distinction between whether someone can be classified as an independent contractor, whether they can be classified as an employee, and that's quite important from our perspective. And there's some factors that you would look at. How would it apply in the European context? So if someone understands the rules here and they're thinking about going abroad and they certainly don't want to establish a commercial presence abroad in a particular jurisdiction and inadvertently have an employee that then subjects that company to tax issues and then employee rights and withholdings and everything else, are they the same types of concepts in Europe?
Yeah, I mean, it's a hot topic in Europe as well. I mean, particularly we're looking around the sort of gig workers, the gig economy, and so we've had all the kind of same conversations around things like Uber drivers and there's various people, and in fact there was I think who it was, one of the companies who've just agreed that they're going to start offering things like holiday pay and sick leave and stuff like that to people who are technically self-employed. So it's a massively controversial area. Unfortunately, none of us are employment lawyers, which is where this would very strictly fall. So I think you need to go and get specialist advice. Oh, hang on, there's Steve. Fantastic.
It's pretty equivalent. So W2 and 1099 very roughly the same in Europe. Difference is that if you get it wrong, not only do you have the tax implications that you would have here in the US if you've got the you get satisfied, but you also have all the accrued employment rights that we have in Europe, which is much higher level. You would have back pay and stuff like that. So you don't want to get it wrong. There is a possibility of using an international PEO like you have in the US PEOs, but this is an entire category itself.
So for those on the tape, Steve Wilson is another OC partner who's here in the United States in New York and spending some time in California. And he basically said, I'm going to try and summarize this. Tell me if I got this wrong. That it's very similar in the United States. The rules in Europe are very similar to the United States rules, similar to the W2 rules, with the added risk that if you get it wrong, there's all that extra employee accounting and back pay that you have to be liable for. And so make sure you get good advice right off the bat. Fair? Okay. So I'm going to ask one more question, if it's okay. Anyone else have a burning question from the audience? All right, so the one last question, which just maybe it seemed quite basic, is in the United States we have the blessing that we're pretty much putting packaging in one language, in English. And you had mentioned, Katie, that you have safety conditions of use. Besides the images that you put up, you have to, and on websites as well, you have to put it in all the different languages of the EU. How does an entity here in the United States who's trying to sell into Europe and is trying to take advantage of the market, but may not be, and that's where the growth may be, they may not have all the different packaging in sufficient quantities to ship full containers in French and then full containers in German languages, but they have the products themselves. Should they then perhaps go, and I see some people from the Netherlands Investment Authority, should they then perhaps have an investment arm in Amsterdam and then like a container in a warehouse, and then they're repackaging in that place, which seems like it's a significantly larger effort? How do you deal with that language and labeling requirements for the goods once it's in?
Okay, so practically speaking, most people will try and put it all onto one label if they can, or they will do maybe, say, 3 variants of it. So they'll have a product and a language that's going to go out to Eastern Europe. They'll have another one maybe going to Western Europe, or sometimes also, of course, they'll reposition what they're using for the US and Canada, which they'll have in French as well, and that's what goes to the French market. So it's not about creating lots and lots of different packagings, because that's hugely expensive and not a sensible way of doing it. And then there are sort of the tricks of those sort of peel-off labels. So you kind of find you've got a booklet practically coming out of your moisturizer or whatever it is in several different languages. So there are ways and means, but it is a real challenge.
Okay. All right. Without any objection, I'm going to turn now towards what I know a lot of people in the room were kind of looking forward to, which was Brexit. If we're going to have it even at all, I think seems to be the ongoing question for a lot of people. Is it going to be in March? Is it going to be in 2020? Will there be another referendum? And as we move towards it, I'm keen to understand as well a lot of the GDPR issues. And I want to understand from perspectives. I know that, we have people and our own clients who may have suppliers in the UK and data kept in EU member states, and how will Brexit affect this types of issue? And with Inventable as well, we have, people like Kelly Bastide and Shannon Jaworski and Milos Tividanis and others who practice in this area as well. But we're trying to understand how we work together. So with that, Katie.
I feel like I've been passed the poison chalice here, I have to say. Slight challenge when you're asked to come and speak about Brexit. And I have very optimistically entitled the next slide as the current position. And frankly, this changes almost by the hour. So it is a slightly a difficult one to call. But look, I'm going to try and give you a bit of a summary of where we think we are, just to set the scene. And then very happy to try and pick up on some specific questions after that. But as we currently stand, unless something happens, the UK is crashing out of Europe on the 29th of March with no deal. Okay, that is the default position. So something has to happen between now and the 29th of March to stop that happening. And that is why, well, maybe if you'd asked me maybe 4 months ago, I'd have said, no, hard Brexit, no, we'll be fine. Now, because of the time frame, that no deal scenario is a very, very real scenario. So I'm sure you have seen the various sort of attempts within Parliament to try and reach some kind of consensus amongst the MPs as to what we are going to do. And it was May's deal, Prime Minister May's deal, which she spent 2 years negotiating with the European Union, which was then roundly defeated in the House of Commons on the 15th of January. 432 to 202, a historic defeat. So they've really said, no, we definitely don't want that deal. So the problem is we don't have any other deal. So then we move on to what happened last week, where you had various MPs who were trying to propose amendments. And they were the voting between them was very, very narrow. Some of those amendments were sort of failing by about 8 votes. So there's, the House is really split as to what to do. But the one that did get through was what's called the Brady Amendment, which in effect says, look, the House of Commons would accept May's deal, but we won't accept it with the Irish backstop as it's currently drafted. You've got to go back and find some kind of alternative arrangements. So Mrs May has said, yes, I will go back to the European Union and try and find some alternative arrangements for the Irish backstop. Prior to the vote, I think within 5 minutes of the amendment being voted through, the EU has been saying very, very clearly the deal's not to be opened. We're not interested in having any other negotiations. But still, Mrs May is continuing. And she's promised to come back to the House of Commons, first of all, on the 13th of February to make a statement, and then a motion will be put forward on the 14th of February for everybody to vote on, and that's probably when we'll see a whole raft of more amendments coming in around the same sort of topics that we saw before. Take no deal off the table, we should have a second referendum, and goodness knows what else. So how do we currently feel? Well, this is kind of how I feel at the moment. This is from The Economist. We're, putting the square peg in the round hole, or in our case, the 3-pin plug into the 2-pin European hole, and it's I think we all feel, irrespective of whether you're a Remainer or a Leaver, that it's a slightly desperate situation. But the EU have been very firm and clear that they're not interested in reopening it. So that's kind of where we currently are. But I just want to have a little bit of a focus on the deal, because the tactic that seems to be being deployed by Mrs. May is that if we keep pushing the can down the road, and the closer we get to the 29th of March and the horror of no deal and hard Brexit means that actually we will just vote the deal through. So the deal still kind of, even though it's been voted out, still sits there as a potential of where we are going to end up. So just a couple of words on the deal, because I think this is still the position that we might be operating on the 29th of March. So just understanding that the deal consists of this withdrawal agreement and also a political declaration. The political declaration really is just sort of 26 pages of aspirational statements. It's the withdrawal agreement that is the kind of most important bit of it. And it covers numerous things. I mean, it's about 585 pages, but just sort of picking up on a few things in the time available. Things like citizens' rights. So if you are an EU citizen sitting within the UK, you are protected. You can remain in the UK, and if you've been there for over 5 years, actually you can seek permanent residency, so they get security. It covers things like the separation procedure, so what's going to happen to cases that are halfway through the European Court of Justice, or procurement procedures that are halfway through, or all sorts of sort of issues that what is going to happen, if you like, on that 29th of March for things that are stuck in the middle of between the UK and European Union positions. The other big and important thing is this point about what is called in the agreement the implementation period. Everybody else refers to it as the transition period. So what that means is, come the 29th of March, if the agreement is signed, we basically have a status quo, so nothing changes. So the EU law that we're currently operating under continues. We continue to follow the EU systems. We can't participate in any of the EU institutions, but there's a status quo, if you like, while we continue to negotiate and hopefully come up with some kind of proper free trade agreement. So, if you like, it's just a lull, and it buys some more time, but it's much needed time. The other thing that kicks in is this Irish backstop, which is obviously proving to be the most controversial issue of the moment. And if that withdrawal agreement is signed, it says that in Northern Ireland will remain in a customs union and a single market with the rest of the EU. So they will continue to be able to trade with Ireland on the same terms in terms of products and goods, the customs union and services within the single market. And that will continue to the transition period. If at the end of the transition period we still haven't worked out what those arrangements are going to look like, it can be extended again. But if actually we still haven't reached an agreement, the backstop kicks in, which means that the rest of Great Britain comes out of the EU and has to be, I think the words are, it has to be aligned or to try and keep to a similar pattern in terms of things like environment, labour and social laws, but Northern Ireland stays in that customs union and single market, in effect creating a border down the Irish Channel. So for Great Britain, we'll be operating on our own rules. For Northern Ireland, they'll be operating on European rules. And that's why it's so controversial. Northern Ireland, obviously, with its huge political upheavals, this goes right to the centre of all the conflict and the issues that are there. Although actually many Northern Irish businesses are, despite what the politicians are saying, would be very happy with that situation because they see themselves in a place where they've got the best of both worlds. They're still operating to the EU rules, and so there's no hard border between the Republic of Ireland and Ireland, but also they're still part of the United Kingdom as well. So actually, it could work out well for them. But that is why it's so controversial. We create a border down the Irish Sea, in effect. So that's the withdrawal agreement that would kick in. But the default position, that position of no deal, just to compare that. So what does that mean? That means that those points I've just been talking about in the withdrawal agreement, that all falls away. We don't have any of that. So we have no transition period whatsoever. We immediately drop out of all of the EU institutions, of all of the laws which we've known about now since 1972. And the UK is in effect treated as a third country by the EU from the moment of exit. From a legal perspective, that means the law that currently sits on our statute book as at the date of exit becomes our law. That is our retained law. What do I mean by retained law? So from a European perspective, we have different types of European laws. We have regulations and we have directives. So a regulation is a very specific piece of legislation that sets out exactly what everybody has to do, and each member state says, fine, we accept that regulation wholesale, and in each member state all we do is actually create some enforcement provisions for it. Okay, so you have all those regulations. We also have directives, and the directive is a bit more like a framework. It sort of suggests what member states should do, sort of an overarching governance principle that we should follow, and then each member state needs to implement their own systems. So where we've got that direct EU legislation, those regulations, that's fine, that goes there, but needs to be corrected, and I'll just come to that in a minute. Where we've got some existing law that we've taken, so we've taken those directives and we've tried to create our own laws, that should be fine as well, but with some amendments too. We've got things like the European Court of Justice case law, which we will recognise up to the date of exit, but we still need to do quite a lot of tweaking both to the existing law, and we also need to create some new law, otherwise we don't have rules to operate under. And it's quite significant. The new law, while we've seen actual acts, completed acts for things like taxation and nuclear safeguards, which is all great, we're only in draft stage for things like trade, immigration, agriculture, and fisheries. So this is a bit like saying, from the US perspective, so from the 29th of March, we currently have no law that governs immigration, no law. So, how people are going to come in and out of the UK, we have no rule book to follow, which as a lawyer I find slightly terrifying. The correcting power bit, so this is a bit where we have to go through all of our current law and say, right, well, it doesn't actually work at the moment because it makes reference to lots of other EU institutions or EU regulators. We have to amend all of that. And we've worked out we need about 600 what's called statutory instruments to amend all that law. We've got 104 of them to date. We've seen 239 in draft, and there are 257 that we haven't even seen. And this has to be in place by the 29th of March. So, yeah, it's going to be it's going to be fun from a legal perspective. So, I mean, that is a massively whistle-stop tour of what I think, as of the moment I walked into this room, the current situation is on Brexit. We produce some really helpful updates. We have a chap who I call Mr. Brexit, whose job is literally to read all of the press statements, all of the stuff that comes out of government, and he writes some very good and actually very witty updates on Brexit. So if you're trying to read something that's a little bit more digestible and sort of lawyer-focused, covering all sectors, then his name's Nick Sodhi, and I've put the link there on the slide so you can hear what our Mr. Brexit has to say. So that's really then open to the floor for your challenging questions.
Sure. And for those on the website, we committed to an hour. So I'm just going to thank the people in the room. I want to thank Melanie Franco and Michelle Chernoff from Venable's side in actually organizing this and making this happen. And from my perspective, I wanted to thank my partners, Jim Nelson and Mark Vecchio, who have a very strong relationship with Osborne Clarke in conjunction with Steve Wilson, who's here, and we're grateful for that as well. So I'm honored to be able to help participate with that. So with that, we can, for those on the website who are listening, this will be the conclusion. However, if you want to stay on, we can open up for questions for other people in the room to talk more about the Brexit issues. Thoughts, questions? Alan? Anything? No? Okay. And I know that Andrea and Alexandre, if you guys have any thoughts from the EU perspective on how Brexit is sort of impacting and what you're seeing from your companies, please. We had talked about that a little bit before we started.
So from a German perspective, or at least what I see, with respect to my clients, they all don't know what to do because they don't know what to prepare, right? Because, so when they come to us and ask us, what shall we do? How can we perfectly be prepared? We say, well, it depends. So that's also a bit frustrating for us. But of course, we are all concerned, deeply concerned, to be honest.
Mm.
I mean, the situation with respect to IP rights is settled, because if you have, for example, a European or an EU trademark, you will get, which is registered at the date of March 29, you will get a kind of copy, a national trademark copy, so you will still be protected in the UK. And if the trademark is still in the application status, you will be granted a 9 months period in which you can apply for a UK national trademark and can rely on the priority date of the European trademark. But nevertheless, that's at least what I see. We are all concerned.
Yes, and maybe one other thing is that should we be in a no-deal situation, there will be, as Katie said, no transition period. So that means that we have to be prepared. We don't know exactly to what, and it has to be done in a few weeks. So that's an issue.
Katie, did you want to lob in anything else?
We're in a situation where we're going to be in e-discovery around the time that the hard exit is happening. And our e-discovery is occurring in the EU, but our data collection centers in the UK. How will the data privacy laws roll over, if at all? And if there's a hard exit, will there be a stop, and we're all going to kind of be in treading deep water, trying to figure out what to do, because now we don't have data privacy protections anymore with our ongoing data collection. We'll definitely continue to be going after the January.
So just to summarize for those who didn't hear it because of the microphone, and Katie, tell me if I missed it. If there's a hard exit, your processor for the data collection is physically located in the UK, but the collection is occurring in the EU, and what's going to be the impact if there's that hard exit, which will continue on after whatever that March date's going to be, March 29th, and how will you sort of deal with that? Right.
So, the UK government have helpfully produced what they're calling no-deal notices. So, there are hundreds and hundreds of them sort of covering all sorts of different sectors. And certainly, I'm not a data protection specialist, but what I'm understanding is that they're saying that the UK will still recognise that flow of data. And we've got the equivalent notices going on in the EU. Because where's your action taking place?
So it's an action in the District of Delaware here, but we have the client has repositories in here in and our discovery representative.
Okay, so I think, well, I partly hope that common sense will kick in with a lot of these things, frankly. I suspect you'll be okay, but certainly my understanding of those no-deal notices is that there will still be a flow of data. But I don't know if Steve has got any other view on that.
I think that's right. It's like across the approach, because from a legal perspective, as of the data practice, there can be no flow between the UK and the rest of the EU until the ruling is given as to the UK's retention and security of data. The good news is, if it's good, that GDPR will be adopted exactly the same in the UK as in UK law as it currently is as European law in the UK. So for anybody that's already put efforts into applying the GDPR in the UK, that's not going to be waiting. That's going to be the law going forward. And the whole point is that will give the UK equivalency, so that hopefully the EU will rule that the flow of data is permissible between the rest of the EU and the UK and vice versa. But that has to be ruled. And so, as you said as a panel, the issue is the hard Brexit. There's no time to prepare for that, and so all out. And therefore, that's where you have to common sense. But the regulators on March 30th are not suddenly going to stop the flow of data from the UK to the EU or vice versa. And I think the point is that in both sides' interest to have a sensible approach here, because there's a lot of EU business in the UK and
All right, so let me try and summarize that long thing to a couple of sentences. So Steve Wilson from Osborne Clarke, I think what he said was, and Steve, correct me if I'm wrong, there's going to be a sensible approach. If a hard Brexit happens on March 29th, on March 30th, then hopefully the regulators will know that there will be a law that's going to be passed in the UK that will essentially have equivalency requirements and adopt GDPR. All the efforts to implement GDPR in the UK are not wasted, and hopefully common sense will prevail so that there's not going to be a cutoff of the data flow back and forth. So that,
And hopefully to answer Kate's worry until the end of 2025.
yeah, and if the withdrawal is approved, then there's an extension out to 2020. At least from the U.S. perspective with GDPR, I think there's only 3 ways to comply. You can either adopt the model clauses currently, number 1. Number 2, there's the Privacy Shield, which I think is through the U.S. Department of Commerce, which requires an affirmative public list that's out there that you're complying with certain things. And the third is consent. And I think that in California, they're proposing a law which has requirements which people are foreshadowing are very close to the GDPR types of data protection requirements. And if that passes, and California has such a large impact on regulations in the United States throughout, maybe the United States will be moving a lot closer anyway towards what the European Union currently has and the UK currently has under the GDPR. So anything else? Okay.
Any other questions?
Any other questions? All right. Well, thank you so much for coming, and sorry we went over about 5 minutes, and we appreciate your time.